in the objections that the lead counsel filed, and those facts were made clear in the originating action I brought before the Abia State High Court to decide these questions. So these are the issues before you, so that before anybody prejudges and begins to look at him as some sort of a fugitive that deserved what he got, no. An international fugitive also has some rights, and that right can be found in any national law. So what they could have done that made all these things who are by law unnecessary would have been to subject him to due process of law in Kenya, the due process law of extradition. And when you do, the Kenyan court will test whether the reasons for his extradition met the political offense exception, or was caught up with it, or was barred by it. So, but when you don't do that, and you resort to the act of extraordinary rendition, you have created insurmountable barriers to prosecution of the person you rendered. I can understand the confusion or a little bit of lack of understanding amongst Nigerians on this very concept of extraordinary rendition. But let me use just one small example to explain it to you, because it's an issue of first impression to this country. In 1984, Nigeria tried to do extraordinary rendition of Omar Diko. He fell. They put him in a crate. He fell. And what happened? Britain took very strong countervailing measures. Britain severed diplomatic relations with Nigeria for 2 years. 17 persons were arrested, and 4 were convicted, and they served between 6 to 8 years of hard labor imprisonment in the UK. The Nigerian aircraft that was the vehicle for the rendition was seized. The pilot was arrested and detained, and too many other things happened. People were deported, left, front, and center. So if Diko's rendition, attempted rendition, drew the eye of the British government and condemnation of the world community, Nnamdi Kanu should draw even more, because his own is successful. Diko's wasn't. And Diko was a mere resident of the United Kingdom. Nnamdi Kanu is a citizen of the United Kingdom. And he had a history of standing by to face his trial. That standing by, that readiness for his trial was not broken by him. It was broken by the prosecutor himself, who turned around and renditioned him later. You cannot profit from your own wrong. So even though this type of thing has not happened before in Nigeria to the point of bringing it before the judicial authorities, it has happened now. So it's before the judicial authorities to make a ruling on it one way or the other. But I can tell you that our theory, our position will prevail. Thank you.
Are you okay?
I'm okay.
So are you okay, right?
Yeah. Okay.
Wonderful.
So they want to. So what the question I would like to ask him is the status of the case that's instituted as the National Criminal Court. Give it number. Hello. Hello, sir.
Okay.
What is the status of who is now?
Alright, sir. Tell Ruben that this is not working.
Okay. Just drop it down.
Just drop it on the ground.
When I'm asking of the status, has it been physical hearing?
You're asking about the lawsuit we brought against the Secretary of State, Tony Blinken, and the Secretary of Defense, Lloyd Austin.
About the one you just filed at
The IPOB, yes. Well, what's the status of that case? We filed the complaint. Basically, the background is we think it's very clear that because of the government of Nigeria's fear of losing certainly the battle in public opinion of their maltreatment of the Biafrans and IPOB, that the government paid a purported professor at the University of Baltimore to write this polemic against IPOP. It really is quite amateurish. It accuses Biafrans of taking machetes and chopping children's heads off, burying them in graves. There's nothing specific about the incidents at all. It's just all very large numbers, 344% increase of attacks on security personnel, no place, no time, no names, nothing. And as a consequence of this tirade, which was urging the Secretary of State in the United States to list IPOB as a terrorist organization, which is absurd, because among other things, you have to be threatening the security interests of the United States. As far as I know, no Biafran has ever set a glove on any American. That we then have brought a defamation suit. It's a 21-count defamation suit for the attempt to ruin the reputation of IPOB in the United States, not only against the author, who seemed to be a Moroccan who worked in Buhari's campaign under David Axelrod earlier in 2015, but against his employer, the University of Baltimore, which we suspect received money from the government of Nigeria in order to permit this professor to identify himself with the government. And also, we suspect that the Washington Times, which was the newspaper organ that published this article, of being paid off in some way or other to publish something that clearly would not meet journalistic standards under any ordinary test. One of the reasons why we're fortified in that belief is that immediately after the article was published, I wrote a letter to the editor pointing out all the multiple misstatements in the article. I received immediately a response from the Washington Times, and I've worked with them for a long time, saying, we will publish your letter the next day. And I sent that, I think to Ejiofor, to distribute. Well, it didn't appear the next day. It hasn't appeared ever since. It seems quite clear that somebody upstairs in the Washington Times was getting paid off as a favor, because the article that we have challenged as defamatory it's amateurish. It is not journalistically professional. So why would the Washington Times risk its brand, its status as a newspaper by publishing this unless they got a payoff? So we filed this yesterday. I got summons. That summons is something that requires you to serve the defendant so they know they have 21 days to respond, or there'll be a default judgment. So we're in the 21-day period now, because we've now filed and got the summons on the way to distribute the complaints. So that's where that stands at present.
I don't know, sir, if last from me, when you filed this suit, did you make any monetary demand for damages? I think there is
the way in which you typically in the United States plead, oftentimes we just say damages according to proof at trial, because until and sometimes in a situation of defamation, oftentimes the injury occurs in the form of people who don't talk to you anymore. They don't show up on your doorstep. So it's hard to prove something directly. That doesn't happen, right? But we did ask for $50 million in damages, because we think this is punitive damages as well. Punitive damages are things that are given not because of harm to you, but because the defendant acted out of ill will or spite. They had no redeeming purpose. Then just to try to punish and to deter repetition, you can get punitive damages, which oftentimes are 20, 30 times what your compensatory damages are. So anyway, that's out there. I have no doubt that the Washington Times says liability insurance, defamation insurance. The individual, I'm sure, who doesn't. The University of Baltimore may. But that's where it stands right now.
Thank you very much.
Thank you so much, also.
Thank you.
Thank you.
This test.
I think we're done.
You're done, yeah.
Thank you.
Okay, thank you. Let's make more copies.
And the soft copy too, we appreciate it.
They'll fall it now. I will send it to you.
I wanted to disagree with you.
Ekene mo no na no ya no no ndi kai wu na ndi kano bụ ndị mere mkparịta ụka taa ha na ndị nta akụkọ na Abuja. Anyị ka ga-ewetara unu otu o si aga na Abuja. Ya gazie n'ụkọ dị mgbe ọzọ.